Now, Shweta, back to you. Can you highlight the current labor law compliances and their exceptions?
So in this, what I would do, Pramita, is because labor law compliances, there are a lot of compliances, but I would talk about what we have experienced. A lot of questions and queries that have been posed to us with respect to labor law compliance and HR related issues. Plethora of them. So look at the scenario. We have almost about 416 labor laws and rules between the center, the state and the union territories, and which leads to almost about 278 different types of filings. And we have almost approximately 1000 different kinds of forms and registers to fill up. So for an organization to maintain statutory records under various acts such as Shop and Establishment Act, under the Minimum Wages Act, the Payment of Wages Act, the Equal Remuneration Act, Payment of Bonus Act, Factories Act, Contract Labor Regulation and Abolition Act. So there are plethora of laws that have to be, the statutory records that have to be maintained. So these laws regulate the hours of work, the payment of wages, the leaves, the holidays, the terms of service and other conditions of the people who are working and who are employed. And all of these lead to applicability of statutory records such as muster rolls, wage registers, leave and attendance registers, overtime registers. You have to maintain some of them physically. Some of the registers are required to be maintained electronically. So if you look back a little bit to the Code of Wages of 2019, which was passed by the Indian Parliament in August of 2019, it was the first step by the Indian legislature towards harmonizing and simplifying the compliance norms with respect to four major wage laws, which was the Payment of Wages Act, the Minimum Wages Act, the Payment of Bonus Act, and the Equal Remuneration Act. So the object of the code was to widen the applicability of labor laws to a larger workforce and to ensure equity and promote the ease of setting up of doing business in the country. However, just when the Code of Wages 2019 was to be implemented, we are now facing these challenging times. So the key assumption that the labor law regulation is that there is an assumption that an employee shall work for a particular location. It is very location specific till now, except for certain aberration in the businesses like IT company and ITES company. Most of us still have the geographical location of working. And therefore, there is a need which is a reason with respect to labor laws which shall require for provisioning of recording leave and attendance, hours of work when you're remotely working. So the biggest HR related challenge in India which many businesses are facing stems from the non-uniformity of the impact of the pandemic across the geographical landscape in India. So you don't have to only take into consideration your central laws, but also your state laws and UT laws, and there are certain filings which are very city specific. So the extent of regulation to implement like social distancing, for an example, which can vary from district to district, even within the states. And therefore, the various areas that have been identified as red zones have been completely sealed off, and there are various queries that have been rising around out of these issues. So the federal structure in India has led to the states also issuing guidelines along with the union government on various aspects of lockdown. And that has increased the challenges and identifying, implementing a very compliant strategy for companies having Pan India presence. In fact, one of the companies that we are representing has its business across different states, and they are into security solution services. So the initial challenge was whether security solution business will be allowed to fall under the essential services or not, and if not, then what happens to these premises which will be left vacant because the security personnel will not be able to reach, and therefore there will be a gap in the security services being provided, and therefore it should fall within the essential services. Now ultimately the government came up with a guideline to include them. So these kind of challenges that different organizations are facing at a different level is something which is very unique in today's time. And in fact, work from home, for that matter, is a where the technological infrastructure has come with its own set of challenges, especially in terms of management of the employees and ensuring that not only the management but the employees to manage their ethical standards. And the Indian employment statutes are very silent about a work from home concept at the present. So there is no statutory definition, there are no specific guidelines. The organizations did not even have a policy with respect to work from home to a greater extent. So if you look at the kind of challenges that we are facing are immense. So if you have time, I can just quickly share some of my thoughts on this further.
Yes, please. Please.
So like various state governments and central governments, they have issued various advisories for promoting work from home. So under the current circumstances where lockdown have been implemented and commercial and industrial establishments are closed pursuant to the government order, the absence of the employees from work, it cannot be adjusted towards the paid or unpaid leaves. So if the establishments are voluntarily closed in the absence of specific orders from the government, the employers and employees can mutually agree on adjustment of paid and unpaid leaves. But availing leave on a particular day is an employee's prerogative and they cannot be forced to utilize all the leaves. So a lot of questions which arose for many organizations were therefore, with respect to forced leaves or adjustment of paid leaves and unpaid leaves, and the in case of an employee, if he is infected or he is requiring a sickness leave, otherwise, then the prescribed number of sickness leaves under the applicable law. So what kind of a scenario would it be and how many number of days can it be allowed? Ultimately, the government came up with certain notifications in this regard as well. And in the event of a prolonged illness, the employees can be provided unpaid leaves for the required duration. And therefore, the establishments which are covered under the ASI Act, the longer duration of sickness leave was possible. For an employee who is required to administer self-quarantine as a consequence of discharging his official functions, such employees should be provided with paid leaves for the same. However, if the employee is required to do the same due to his personal actions, then they can be required to utilize their outstanding leaves for the same. Then there is a talk about reduction in pay. Whether the reduction in pay can be done between the employer and employee. One, if it is being done on a mutual understanding between the parties, then there is no issue. But if a reduction in pay has to be forced upon the employees, whether that can be done or not is a major challenge. In fact, there is a lot of discussion around this and a lot of queries which have come around this. So on 20th of March 2020, the Ministry of Labour and Employment had issued a circular which had advised the industries and the enterprises not to retrench any employee and to continue paying the wages and salaries. Then again on 29th of March, the MHA came up with another order. Now this was under the Disaster Management Act and that required the payment of full wages to the workmen. With the onset of lockdown followed by the string of circulars, orders, clarifications by the different departments, ministries of the Government of India on the issue of payment of salaries and wages to employees during this lockdown has created a lot of confusion for the employers of the non-essential goods and services segment, including a lot of our clients as well. So we have also been advising our clients on this issue. And if you look at the definition of workman, it includes contract worker, it includes casual worker, it includes migrant worker, and it includes sales promotion employees and different other categories of employees. So the Ministry of Labour and Employment issued a circular and there, I just talked about it, that you cannot terminate the employees and not to cut the wages. But look at the scenario where the organization is not able to do well or do not have the ability to make the payment. Where do you get the wherewithal to be able to meet these kind of circulars? Ultimately, they were all challenged before the Supreme Court. Supreme Court also has, at least in hand and tools, have given some kind of a directive that there should not be any coercive action taken against the organizations who have not been able to make the payment of the salaries and wages of the employees. But what about the other industries? They are still left high and dry.
Right.
So if you look at the kind of direction that it is all taken, it probably seems to have a certain amount of vagueness. So the ultimately the Ministry of Corporate Affairs also on 10th of April came up with a certain clarification, and it said that the payment of salary wages in normal circumstances is a contractual and statutory obligation of the company. And similarly, payment of salaries, wages to employees and workers, even during the lockdown period, is a moral obligation of the employers, as they have no alternative source of employment or livelihood during this period. So while these clarifications have been issued in relation to the questions that have been raised with respect to payment of salaries, wages during lockdown, it would qualify, but now the other question was whether it would qualify as a corporate social responsibility or not. And that was the context in which the Ministry of Corporate Affairs had given this clarification. However, the mind of the ministry at least is now before us, and we at least know that this is the direction that it is going to take. if you look at the Industrial Employment Standing Order rules of 1946, it specifies that the model standing order for governing the employment conditions of the workmen, based on which different industries they are working in. So one of the model standing order embodies that in case of stoppage of work owing to any intervening circumstances, the workmen shall not be eligible for any other compensation apart from the payment of for the time they have been detained from after the stoppage of work. So that is all has been prescribed under the laws. So there are various industries which have their own standing orders, which will also govern the payment of wages to workers when the work has stopped, which may further and employers to take legally compliant decisions in relation to deducting the wages and in relation to the industrial workmen in case it is incapacitated to pay the workmen. So there are various decisions also which are coming from the court in this regard. So what we have been looking at is that these are force majeure circumstances. So if your employment agreements have force majeure clauses, the employers may seek to invoke the same for revision of salaries, including the deduction as proposed in the usually, it could be a 3 days salary, it could be a mutual understanding between the employer and employee. But in the absence of a force majeure clause in the employment agreement, the employers will have to invoke Section 56 of the contract, which will be applicable in these kind of pandemic situations and because of the cessation of work, leading to no business and leading to a doctrine of frustration, which will entail the law of discharge of contract by the reason of supervening impossibility of the act agreed to be done. And therefore, in these kind of circumstances, the performing party will be excused from the performance or discharge as in supervening circumstance, like in these cases, the employers. And therefore, the idea is that if there is an obligation which is to be temporarily or permanently suspended, then the excuse either under the frustration of contract or under the force majeure clause can be taken in order to mitigate the risk of liabilities for the organizations. And of course, I mean, the support and emotional support, and as far as possible, the financial support will be to the workmen and the migrant workmen, to the casual workers, contract workers who are unable to support and sustain during such challenging times as per the requirement of the central government, state government, and also on the humanitarian grounds. And the termination as far as possible or reduction in wages as far as possible should not be done. But in the circumstances that are prevailing today, you cannot force an organization which is going through financial crisis itself to be able to meet all of its obligations. And therefore, we will have to, assess it on a case-to-case basis going forward.
Understood. All right. Thanks, Shweta, for that wonderful summary of the matter. Anumeha, can I move on to you to shed some light on this from an in-house counsel perspective?
So majorly, Pramita, like Shweta said, there is too much of confusion in what we are trying to achieve and the coordination required between various central government and state government notifications. The latest notification or the choice that has been given to employees to reduce the provident fund rate from 12% to 10%, that has its own challenges. So yeah, my only contribution to this topic is we will be absolutely, as an in-house counsel, probably again the bandwidth of how much we can do, because we're supposed to do a lot, be jack of all trades. We would be depending on advisory organizations like Shweta, and we are in continuous touch with them to help us with these. But honestly, at this stage, there's just no possibility of trying to get your hand around everything at the same time. But my overall is to be kind to yourself, one thing at a time. And again, from a compliance head of the organization, put into place all the provisions that you are taking care of. Have your right documentation in place. Things that you cannot build up your business cases, why you are not able to do that, so that if the government comes calling at some point of time, you can establish that this is why, or this is the reason why it was not happening, or why it could not happen despite our best effort. So that documentation part is very important. Keep getting the right legal opinions where it is required. So that's what, as an in-house counsel, is how we are dealing with it.
Great. All right, Anu, to you only, what are the compliance challenges that you're facing as an in-house counsel in resuming operations, resuming offices operations and how to deal with them?
Again, it is quite in line with in line with what we have just discussed, because there are multitude of guidance, multitude of directions which are coming in from various administrative bodies. I can talk about what we did when we kind of resumed our operations in our Gurgaon office. We are a medical device company, so obviously we are in essential commodities, but the point being here is that it still doesn't give you any, it places more responsibility, compliance requests or compliance checklists on you rather than lesser. So we had to bring in line with what was required by the Gurgaon district administration guidelines. It was a huge SOP that everybody had to comply with, and the salient feature of this was that not everything can be done by the employer. A lot depends on the intent of the employee and how much is he willing to comply with it. How do you manage that?
Sure,
How do
sure.
you get the employee to cover and follow the instructions? And if the employee fails in that, how is the employer responsible? To what extent? So you can have all the tapes put in there. You can have temperature monitoring. You can have all the records that are required to do. You can issue instructions for 6 feet social distancing. You can tone down your cafeteria. You can ask employees to bring in their food and water so that there is a lesser extent of the pandemic or COVID to I mean, sorry, I'm just stuck up with that word. So how do you get the employees? So one, we ensured that we followed exactly to the T what the employer could, what we could not. Like I said, we made business cases and got internal approvals as to what is not possible for us to do. We got instructions issued to all the employees. We got them to get their till 17th it was required, but not afterwards. But we got them to get their individual passes. We worked with the government authorities to get passes. We applied for licenses for our Gurgaon offices for us to open. Gave them a plan on how many employees are going to come, what is the percentage of people, why they're supposed to come, because these were our scientists who wanted to access labs. Then every meeting for instruction was recorded, because it's not required under the SOP, but every meeting for instructions to employee was video recorded. Consent buttons were used on our emails in which we took their consent that this is what you're going to do, this is what you're supposed to do. Other than that, we also something which is written intermittently is about availability of sanitizers, and in somewhere in there it is also written availability of hand moisturizers. So while you get your security guards to sanitize your hand, but are you also giving them moisturizer, because then their cracks are appearing. So you have to see through all of those guidelines and figure out what you need to do. Yeah. Are you recording the trainings for your janitorial staff, for your security staff? Are you giving them the proper masks and PPE suits to deal with employees when there is a rush of them? The most how do I say, interesting one was, because my scientists were coming back in my R&D labs, there's a lot of haz waste which is getting generated. Now, as per the law, I have a haz waste deposition area, but there is no organization which is coming to pick up those haz waste. What do I do about it now? And now, not just my lab, all my employees are also start going to generate that bio haz waste, because the gloves that people are using, the security guards are supposed to use gloves. The masks that people are using, if they have to dispose them off, how are you taking care? Because that is also bio haz waste. So right. Are you putting up those specialized bins out there? And this is not going to be just because I am medical devices. This is going to be everywhere. Masks, and what about the if you're using swabs for some kind of testing in your employment premises, those swabs will have to be disposed of. These are some unique challenges. Work with the local laws. figure out and figure out what you can do. Best case scenario, what you can do, build up your business case, get internal approvals, what you cannot do, get your employees to give consents that they are responsible for it, give them, time and again instructions through emails, through your cameras, through your HVAC systems that you're talking about to them, record all of those. Do not use your centralized ACs. All of these compliances are basically more intent facing than really documentation, but whatever you can create around them, it's a very important thing.
Anu, I have a question on this. In fact, now that you're talking about it, how are you dealing with a reluctant employee? Somebody who's now not willing to return to the workplace.
Yeah, so that was the previous question. Yeah, the previous question, Shweta, about have you updated your employee policies around it? And again, it's a very fine balance, because these are some of, if you include penalizations and incentivization for doing this, you will be changing conditions of employment, right? So so then get your, we have put in there in the policy, we have changed those policies, we have circulated it to people, and we are using consent buttons for those employees to say you are giving consent that even though it may not be written in your contract, but here from now it is going to be applicable. That is number one. Number two, we have also established a process of a warning system where if you're seeing doing this because your cameras are on, or if you're seeing doing this, one time there'll be a small warning, then there'll be another oral warning, written warning. We haven't reached the stage where we are saying that this is a breach of employment conditions, but if this keeps going on, if the requirements from the law keep coming in, we will have to reach that stage. But at this moment, we are dealing with the warning structure. Some kind of your supervisor will be informed, your supervisor will be informed, you're given an oral warning. Those kind of hierarchical conditions that we're using. Basic line, Shweta, like I said, not possible to comply with everything, but that is where a compliance officer is required to walk that line and advise the organization so that we can show the intent and show the documents around it, whether or not we are fully successful on it or not, because being fully successful, even the government doesn't know what it wants right now.
Right, that's true.